it's audio only, not video. And the audio, from what I understand, is you can't understand what's being said.
The video from holding cells 1 and 2 when Mr. Sanchez was there has been purged, destroyed, cannot be recovered. State of Texas versus Jose Sanchez. Could I have parties announced for the record for the state?
Hank Wilkins for the state.
Defense?
Eric Baker for Mr. Sanchez, Your Honor.
And are you Mr. Sanchez?
Yes, ma'am.
All right. The reason we are here is the defense alleges and your client alleges that there was a video in a holding cell of your client, and it is potentially Brady
Yes, Your
with regards to this case. Is that correct?
That's correct, Your Honor. Yes.
All right. State, are you prepared to proceed?
We are, Your Honor.
Defense, are you prepared?
Yes, Your Honor.
All right. State, do you have any witnesses?
Well, it's really, I guess more of a defense witness.
I guess I'll take this. I wouldn't mind taking the lead if the state's okay with it.
All right. Who would you call?
We would call Deputy Chief Pruitt of the Alamo Heights Police Department.
All right. Deputy Chief, if you could raise your right hand for me. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I did.
All right, you can lower your hand. Just make sure you keep your voice up for the court reporter. If you could state your name for the record, please.
Cindy Pruitt.
All right, defense.
Thank you, Your Honor. Deputy Chief Pruitt, thank you for coming in today. So, Deputy Chief, the video that the court was talking about, you're aware of what video that we're talking about, correct? That we're looking for?
That's correct.
Okay. Now, before we get into that, I just want to ask you, when we initially asked for this video, we got word back from your department that there are no videos taken in that area of the department. Were you the one that conveyed that information to Mr. Wilkins?
No, I'm not sure what you mean. There are no videos taken.
So the first request to your office from Mr. Wilkins requested the video that we're talking about today. And my understanding is that your understanding that your office replied back that there was no videotape in existence. In fact, there was no videotape equipment to videotape at all. Was that your response from the office?
No, that wasn't my response. And in fact, I didn't respond to that. I'm not sure. Do you have the response you're questioning
Okay.
about?
The state has your email, but I'll move on. I wanted to know if you were aware of that.
All right, and counsel, so that the record can be clear, when you speak of video, what video are you talking about?
The video of Mr. Sanchez upon his arrest when he was in the holding cell or near the holding cell in Alamo Police Department. You aware of that video?
I'm aware that video doesn't exist.
Okay. And one of the main question, this isn't our first time here, maybe your first time here, ma'am, is the court had a question, and I think I did too, as to when that video was destroyed. Do you have personal knowledge as to what day it was destroyed?
No, we attempted to recover the video, but we don't have any way to determine when it was destroyed because it's a surveillance system that is on a loop. And as new video comes in, because it runs 24 hours a day, it's a very small server, the older video purges off and it just is replaced by the new videos.
You can't testify today as to when that video was purged, correct?
No, sir, I cannot. I can testify to the fact
That's
that...
just a yes or no question, ma'am.
No, sir.
Ma'am, I just talked to you in the back, correct?
Yes.
When we talked about, I asked you, is there anybody who can make that determination or tell the court? We spoke about someone named Marcos, correct?
That is correct.
And when I asked you, you sent an email to Mr. Wilkins yesterday, or 2 days ago, yesterday and Wednesday, that he would not...
Counsel, if you could slow down.
Certainly. That he would not be in attendance today. Is that correct?
That is correct.
And when I asked you why back in the back, you said somebody made the decision that if he wasn't under subpoena, they weren't going to send him. Is that correct?
His leadership for his company made that decision, yes.
So he's really the witness we need to talk to today, not yourself, correct?
Well, there is his supervisor is available today by phone.
Can you come in?
I just found this out right before I came in here. They said they would make him available by phone.
Does he have knowledge of what we're looking for in the background so that we don't have to start over with him?
Yes, he has knowledge, yes.
Okay. When could he come in physically?
That I don't know. I didn't ask him.
Is it available to appear by Zoom?
I believe he could. He's with an IT company that is our vendor.
All right, counsel, would you have any objections to him appearing by Zoom?
I would not, Judge. I just want to make sure that, I know that Marcos has information. I'm just curious as to why we can't produce Marcos. His supervisor is going to be a level up, and Marcos has hands-on.
Well, is Marcos available to appear by Zoom, or does he want to sit
When I
in?
spoke with his supervisor just a moment ago, Your Honor, he was directly involved with the process with Marcos. And he is a higher level IT technician than Marcos even is.
All right, so the defense wants Marcos here. Is that correct?
I think Marcos and his supervisor, Judge, just based on the history of this case, Your Honor.
All right, so I like to cut through the chase. Is Marcos and his supervisor available today by Zoom?
I would have to ask, Your Honor. I asked if they could be available by phone, and he gave me his phone number and said that he was. I didn't ask about Zoom.
All right, does anyone mind us taking a short break so she can see if they're available by Zoom?
Not at all.
Thank you so much. And Deputy Chief, what are the results of your inquiry?
Their HR department is denying them showing up on Zoom. And they said that because they were asked to do a task, they completed the task and they recorded all of the information on the ticket, which was then emailed. That's the only involvement that they have.
All right, well, if you will let them know, they can appear by Zoom or they can be subpoenaed, which means,
Did advise them of that, Your Honor.
all right.
Do you have any objection to me submitting this to the court? This is
Actually, I was going to, no, not at all. In fact, I was going to submit that, Judge. There's an email chain that I think was going to be.
All right, you all want to remark it, and then I'll accept it.
Do you want to make it your exhibit or?
Joint exhibit.
I said if they mark it and offer it into evidence, I'll accept it, if there's no objection.
No, Your Honor. In fact, I was going to offer that.
All right, if you could do it as Defense Exhibit 1. Thank you for trying. I know it's not your fault.
Yes, ma'am.
Your Honor, defense would offer Defense Exhibit 1, which they actually just provided to me. It's an email chain from August 14th through to present, correct?
August, it might be, I'm sorry, can I see it for a moment?
Sure. Or yesterday, I guess the present was probably.
So it should, the earliest communication in this chain is going to be August 7th.
Oh,
Okay.
and is that, yes. And so we would offer that, Judge.
Any objection?
No objection, Your Honor.
All right, Defense Exhibit number 1 is admitted. Is there any other questions for the Deputy Chief?
No, Your Honor, but if we could stay after she's excused, just so I can address the board on this.
I have just a couple of questions.
Yes.
So, Deputy Chief, when you were speaking to the IT folks,
All right, just 1 second. Excuse me, if you all are behind the court reporter, if you all could move your conversation and move the inmates this way, that way it's not behind her. All right, you may continue.
did they tell you how far back that those videos are saved on the server from that particular camera?
They said when they started looking after our request to see if they could locate the videos only existed back to March 12th, 2023.
2023, okay. And the date of offense is in 2022.
That's correct.
Okay. And so have you made a diligent search for these videos once you were notified by the Bear County DA's office that we were looking for any additional videos?
Yes, sir, we did. We, like I said, we reached out to our IT provider and requested their assistance in trying to recover any purged videos.
Okay. And so I've spoken to Ginger Leal, one of y'all's employees about, and she.
Oh, Hank, could you speak up?
Oh, yes, ma'am. Sorry, Diana. When I spoke to Miss Leal, she looped you into that email chain, and so some of your emails and some of your efforts are reflected in that email chain, right?
That's correct.
And so, could you just tell the judge kind of briefly what you did once we were looking for the videos?
I reached out to Barcom. I submitted a ticket, which is how we request assistance, and asked them to see if they could look through the Exact Vision server and find any video that may have been purged and see if it was recoverable on the date in question.
Okay. And could you describe how that server works just briefly to the judge? It's sort of, it's running, is that camera running 12 hours a day, 24 hours a day?
24 hours a day. That server, it operates not only the holding cell camera, but the camera inside the patrol room, the cameras in City Hall, and our parking lot and public works yard. So the server runs 24 hours a day. And so as new information comes in, a new video comes in, old video falls off.
And so it's your testimony that this thing is running. As it fills up, the old videos are removed to make room for the new videos.
They are purged from the system to make room. Yes.
Okay. Is there anything else that I forgot to ask you that you think it's important the judge to know?
No, sir.
That's what.
Is there anything else that I forgot to ask you that you feel like it's important for the judge to know?
No, sir.
I pass the witness, Judge.
Deputy Chief Pruitt, the description of how the server works that you just gave to the state, is that from your personal knowledge?
Yes.
Okay, so what training, background, experience do you have in technology or servers?
I don't.
Okay, so how did you ascertain personally how that server works?
That's how it was explained to us when it was installed.
So,
In 2014.
okay, so that was my question. Your testimony you just gave is based on what somebody told you, correct?
That is correct.
Okay. And who was that told you that?
It was 2014. I don't recall.
Okay. Now, are you aware, maybe I asked you this before, that the prosecutor, Mr. Wilkins here, upon his first request for video of the holding cell area, the response from your department was, there is no camera there. Are you aware of that?
No, sir. Where was that response, if I may ask?
Okay, well, I'm part of the state. I just wanted to know if you were, I just wanted to know if you were aware of that.
All right, everyone, please keep your voice up because everyone starts with their voice this level and then you trail down and lower your voice, and it makes it difficult for the court reporter to hear and for me to hear.
Certainly. I feel like I'm yelling in her ear.
No, you're not yelling.
Okay. So, so that wasn't true. If somebody told the state from your office that there was no video recording equipment in that area, no videos taken, that would not be the truth, correct?
That would be correct. There are videos that the cell and the patrol room are video recorded.
Okay. And why is it that you record videos there?
Primarily, it's an observation. Our dispatchers monitor the cameras just like they monitor the City Hall cameras and the parking lot cameras in case there is a problem with a prisoner.
And those videos are saved, at least still accessible for some period of time.
That's correct.
And do sometimes defendants make confessions on those videos that you can then send to the prosecutor?
Our confessions are recorded on our body-worn cameras.
Okay. If have someone in a holding cell, and they confess there, it would also be captured on the video about the holding cell, correct?
I suppose it would be. The microphone is not a very good one.
In fact, that brings me to my next question. Is the device that takes the audio down the same device that records the video?
I do not know.
Okay, because there is still in existence audio from the day of Mr. Sanchez's arrest, just not the video, correct?
It's my understanding that some audio files were recovered, but they are almost incomprehensible. You can't understand what is being said.
I would agree. I've tried to can't hear anything. So that's so you don't know if there's two separate recording.
No, sir, I do not.
Okay, so we would probably be better off asking those people that we've spoken about.
Well,
correct.
Big State Electrical, from my understanding, Big State Electrical is the one that installed the exact vision. And that is part of Barcom's contention, is that they are not the subject matter experts on the exact vision.
Electrical companies install servers, but they don't understand how servers work, correct?
Not any more than I do, probably.
All right, okay. At this time, Judge, I don't have any further questions.
All right, any further questions?
No questions, Judge.
All right, I have a couple of questions. And counsel, I believe you'll be able to answer when the video was requested.
The video was first requested, Judge, Let me put this file down. I've got a
Sure.
I have June 22nd.
That sounds about right.
What date?
June 22nd.
And is that June 22nd of 2023?
Yes, ma'am.
All right, and that's what I have on the docket sheet. Now, when was it purged? Do we know the date or not?
That's what the court was trying to find out. For some reason, we can't seem to get to the bottom of that. It's a very simple question.
And will the persons who are going to be subpoenaed, would they know when the video was purged?
No, ma'am, I've asked that question repeatedly, and they say there is absolutely no way to determine that because of the way it operates.
Okay.
My understanding, Judge, is when we first requested the video, they couldn't get anything before March 12th of 2023 off the server.
That's correct.
So it's not as if I don't think there was any on purpose erasing or keeping over or anything. I believe my understanding of the way the server works is it's kind of running all the time, 24 hours a day.
And I don't mean to be.
So we'll need to have that witness come in to testify to that. So the video records that we are seeking, and I say we, but that defense wants, is that the videos for prisoner cell 1 and 2?
Yes, sure. A holding cell. Yes, I guess it's like a cage.
That's a holding cell.
Okay.
All right, holding cell 1 and 2. And you're stating that the video from holding cell 1 and 2 has been purged.
That's correct.
The audio, is there audio in holding cells 1 and 2?
My understanding that they're, you mean all the time?
Yes.
All the time, yes.
All right. The audio from holding cell 1 and 2, is that, do you still have that, or was that purged?
It's my understanding they recovered some, and it was given over to the court.
All right. And when you say recovered some, is it recovered some of Mr. Jose Sanchez?
It's hard to tell.
Interaction?
It's audio only, not video. And the audio, from what I understand, is you can't understand what's being said.
All right. No, I understand that. But the audio is it the audio that would have been playing or recording when Mr. Sanchez was in holding cells 1 and 2?
It was recovered, the audio that was recovered was during the time frame that we requested.
Okay. So the only thing that has been purged is not the audio, it's the video for holding cell 1 and 2.
From my understanding, it was all purged, but they were able to recover audio only.
Okay, no. I'm off the audio now. I'm back to video.
I'm sorry.
That's okay. So my understanding is, and I just want the record to be clear, the video from holding cells 1 and 2 when Mr. Sanchez was there has been purged, destroyed, cannot be recovered.
That's correct. Ma'am.
All right. And other than the video and holding cell 1 and 2, counsel, is there any other video that may have what you're looking for?
Your Honor, I was informed through this process that there is also a camera in the office adjacent to holding cell 1 and 2. I did not ask for that because I was not aware of it, and I will offer for the record, and maybe we can put this on the record, that the reason I wasn't is on my first request, I was told through the state by the Allen Heights Police Department that there was no recording devices, that they did not record in the board.
All right, Deputy Chief, do you know whether or not the camera that's adjacent to holding cells 1 and 2, if there would still be a video available during the time that Mr. Sanchez was there, or has it also been purged?
I can say that it all operates on the same system. It would be my assumption that it was purged, but I can ask them to look.
All right, if you'll ask them to look into that, and then what we will do, the parties who are not here, we'll place them under subpoena and let them know they will not be allowed to appear by Zoom. They were given a chance to appear by Zoom, so they will have to come to Bexar County 187 District Court and appear in person.
Yes, ma'am.
All right. Is there anything else of this witness?
No, Your Honor.
All right. Thank you so much. Court is calling 2022 CR 3724, State of Texas versus Chelsea Monk. Can I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense.
John Young for the defense.
And are you Miss Monk?
Yes, ma'am.
All right, Miss Monk. I'm going to show you what's entitled True Bill of Indictment. Did you review that document
Yes, ma'am.
with your attorney?
Yes, ma'am.
And did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Monk, I'm showing you what's entitled Court Admonishments. Did you review that with your attorney? Did
Yes,
you
ma'am.
understand it? Did you sign it?
Yes, ma'am.
Did you understand you're charged with possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Your Honor, in this case, she had been found incompetent in Judge Carruthers' court after an evaluation. She had been reevaluated recently and had her competency restored on Tuesday. And that is why we are here today. And I also believe she is competent.
All right, and do you believe she was sane at the time of the offense?
I do.
Ms. Buck, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed under 1244 to 360 days in the Bexar County Jail. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor, she has 438 actual days in jail.
All right, state, is that the plea?
It is, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
There have not, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State Exhibit number 1.
No objection, Your Honor.
All right, state, you may continue to confer.
Thank you.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it at all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial?
Yes, ma'am.
A right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
As you've noted, Your Honor, my client is rather eager to get this all behind her. Her father has hired me to represent her, and I believe that the family unit will be very stable.
All right, off the record for a moment. Counsel, you're blocking the deputy's line of vision.
Sorry.
All right, we're back on the record. All right, does she have any type of mental health or treatment set up for her?
I don't believe so, Your Honor, and I'm honestly not sure what the reason for the original referral was. I've since I've been hired, which was about 3 or 4 months ago, I've never seen any indication that she had any lack of competency. I believe there may have been some issue at the time of her arrest about a burglary charge that did not go forward. But I've never seen any indication that she has had a problem with competency.
All right. So Ms. Mock,
Yes, ma'am.
you're looking healthy right now. Do you remember how you used to look?
Yes, ma'am.
All right. Can you show that to her?
Wow.
So I don't want you to have any issues. I know that you're getting offered this offer and it's a judgment satisfied. I'm going to give that to you, but you don't want to go back to being that person. I can see you. Your eyes are bright, shiny. You're understanding and focus. If you fall off track, don't be that person where somebody's identifying a body and it's yours.
Yes, ma'am.
There are so many places where you can get help now, help for drug treatment, help if you have mental health issues, and it's all free. You just have to ask for it. So don't leave the jail and go celebrate. Don't go with your friends, people who are encouraging you to use, because you know what? Those people are not your friends.
Yes, ma'am.
So the same person who hired your attorney, your father, that's the person who cares about you. So you need to go straight knocking on their door and say, I need help. You know, can you help me get treatment? Can you help me do this? Because otherwise you're going to backslide and you may get lucky and just look like that person in that photo, or he may have to identify your body. You understand?
Yes, ma'am.
All right. So I'm going to find you guilty, sentence you to 360 days under 1244, give you credit for any time served, and I will show that the judgment is satisfied.
Thank you.
You're welcome. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. You understand?
Yes, ma'am.
All right, we can go off the record. If
Okay,
something happens and you can't find a place for treatment or find mental health treatment or drug treatment, you can always come back to this court and I will give you information. We'll make sure you get the help you need.
Yes, ma'am. Thank you.
All right, good luck.
All right, thanks.
Court is calling 2023 CR 3512, State of Texas versus Rudy Luna. Can I have parties announced for the record for the state?
Hank Wilkins for the state.
Defense?
Louis Martinez.
All right. You entered a plea of guilty on December 7th. According to the plea bargain agreement, punishments be assessed at 3 years in the prison, and the state is recommending community supervision.
So Judge, the only real issue that I need to speak to is what kind of treatment options the court wants to employ when it comes to Mr. Luna.
Okay, just give me one moment. Was a PSI done for him?
It was, Judge. I've got a copy of it right here.
All right, I'm just pulling up his TAP evaluation. All right, have both parties had a chance to review the PSI report?
Well, because we're recommending probation, Judge, yes, ma'am.
All right, any
And we
objections?
have, Judge, no, I don't have any objections.
All right, so according to the PSI report, it says his guilt is minimized. And then TAP evaluation is recommending inpatient treatment.
Well, Judge, and I don't think that he's minimizing his guilt. I think the issue, I think, is that Mr. Luna, indicated to the TAP evaluator and to PSI that he does not, currently believe that he needs any kind of intensive alcohol treatment. I think that's where the issue is going to be. And I'd like to speak to that when the court is ready for it.
Yes, I'm ready for it.
Okay. So, as the court can see, Mr. Luna's criminal history consists of 2 other DWIs in this one. He had not had a DWI in about 18 years when this happened. And there were some difficulties in the family, and Mr. Luna just got into some bad habits again. While he was on bond, he had an issue with his ignition interlock in March of 23. That was a year ago, Judge. The way the court dealt with it at that time was to increase the supervision, have him test weekly, and have him do 90 minutes and, 90 meetings in 90 days. And he's done those things. And all that was very beneficial to Mr. Luna. Helped him to kind of look in the mirror and decide that he needed to start doing things differently, that he had gotten into some bad habits and needed to get out of those habits. And so since March of last year, Mr. Luna has been compliant with his conditions of bond, to the point, Judge, where I truly believe that he's ready to be compliant, cooperative, and to fulfill all his conditions of probation. So what I ask the court at this time to consider is to consider intensive outpatient treatment rather than sending him to SADF. He is working, the family does need the income. And as the court can see over the past year, Mr. Luna's in a position where he can be compliant with the court and fulfill his conditions.
All right, probation.
Yes, Judge.
He did complete the 90 sober meetings in 90 days that the court required of him. So, yes. So are you okay with starting with intensive outpatient treatment instead of inpatient treatment? All right, this is what the court is going to do. And I'm sorry, Ms. Abrams, it's Rudy DeLeon Luna. Court is going to sentence you to 3 years in the prison, suspended and probated for 2 years. And to the court, this is a third degree. If you could tell me the court costs. $500 fine, and it's a DWI. Probated, intensive outpatient treatment with probation. We're going to do a referral to felony drug court. Proof of employment within 15 days. No employment as a home health care provider with minors. Admission interlock for half the term. 150 hours of community service restitution. 2 years driver's license suspension. DWI education. VIP live. In lieu of, well, let me ask you this. You can either do 10 days at the Bexar County Jail, or either you can do GPS. It will be partial for work. And if you're going to be working on the GPS, then it's going to be 30 days at GPS. Which would you prefer?
I would do GPS.
All right. In lieu of the 10 days in the Bexar County Jail, the court will order partial GPS for employment for 30 days. And the reason the court is doing GPS as opposed to 10 days in the Bexar County Jail because of health issues, overcrowding, things of that nature.
Yes, Judge, thank you.
Right.
Judge, the court can see.
All right, your court costs are going to be approximately $425 to probably $500. Will you be able to pay that in installments?
Yes, ma'am.
There's to be regular reporting by Zoom or in person. And there's to be regular random UAs, field visits, one time per month for 3 months, and then at probation's discretion. Probation, is there anything else he needs?
Clarify the DWI education that has been listed.
Yes.
That's enough.
Anything else you need from the court to be successful? All right, I'm going to show you a document entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. If something comes up and there's something you need and you feel as though probation is not addressing it, you can always ask the court. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
Thank you, Judge. Excuse me.
Yes. 2022 CR 8756, State of Texas versus Roseanne Garcia. Can I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense?
Will Brooks for the defendant, Judge.
And are you Ms. Garcia?
Yes, Your Honor.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Roseanne Garcia who's placed on deferred adjudication in 2022 CR 8756 for the offense of possession of a controlled substance, penalty group 1, less than 1 gram on March 20th, 2023 for a period of 2 years? Is that you?
Yes, Your Honor.
State.
Yes, Your Honor. Violating condition number 1, on or about the 18th day of May, 2024 in Bear County, Texas, the defendant Roseanne Garcia committed the offense of possessing a controlled substance, penalty group 2, less than 1 gram, violation condition number 1.
Just one moment. Is there a supplement?
No,
I don't believe so, Judge.
All right, so you said possession less than 1 gram?
Yes, Judge.
yes, Your Honor.
All right, what I have is criminal trespass. This is the only thing that the court has.
This is what I have. That's odd.
That might be an old MTR, Judge.
This is September 6th, 2023.
All right, thank you. That's what I had. Okay.
Okay.
All right, how do you plead to that? True or not true?
Okay.
How do you plead to that violation? True or not true?
True, Your Honor.
Your Honor, we waive the remaining violation.
No objections, Judge.
All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility
Yes, Your
and
Honor.
up to a $10,000 fine?
Yes, Your Honor. Sorry.
No problem. Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, Your Honor.
Court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor, and that is to enter adjudication on this case and revoke the individual's community supervision. Sentence her to 9 months in the state jail facility, and the state will be taking into consideration night bag number 765-745, which is the case you just read true to.
All right, is that the proposed agreement?
Yes, it is, Judge.
All right, what has she done on probation?
We actually did complete residential treatment, Your Honor, although this case was picked up very soon thereafter she was released. And,
That's about it.
All right, are you asking the court to follow this agreement? Are you waiving your right to appeal?
Yes, Your Honor.
All right, the court will find you guilty. The court will sentence you to 9 months in the state jail facility, give you credit for any time served. Take in consideration night mag number 765-745. Is there anything else?
The judge would just ask for credit for time she was in custody, which should cover it. She did go to ISF for a period of time, which may not be reflected in the court system.
All right, unless legally I'm required to give her credit for when she was in inpatient treatment, I'm not going to give her credit for that.
Understood, Judge.
Okay. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. And I'm going to ask for therapeutic community. I cannot force them to place you in the program, but you'll need to ask for it as well. It will not increase the time that you're in custody. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing. Sometimes I'll give people credit for time that they've been in inpatient treatment, but what I'm being told is you may have successfully completed inpatient treatment, but you immediately left inpatient treatment, didn't use any of the tools that you had not to use again. You're just like, okay, I'm just doing my time, doing my inpatient treatment, and you immediately leave and you pick up another case. You understand?
Yes, Your Honor.
All right, you're going to have to make better choices. Otherwise, sometimes the last time you use is the last time you use. And if you have children or family members, I don't think you want them on the news having to come down and identify your body because you've got a bad batch of drugs. You understand?
Yes, Your Honor.
All right, good luck to you.
Thank you.
You're
I
welcome.
Appreciate it.
Court is calling 2023 CR 4795, State of Texas versus Abel Rodriguez. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
from Mr. Rodriguez.
All right, and probation, this is person on probation. Are you Abel Rodriguez?
Yes, Your Honor.
Going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Abel Rodriguez who was placed on deferred adjudication in 2023 CR 4795 for the offense of theft $2,500 to $30,000 vehicle on June 8, 2023 for a period of 3 years? Is that you?
Yes, Your Honor.
All right, state.
Yes, Your Honor. Violating condition number 4, in Bear County, Texas, the defendant, Abel Rodriguez, did then and there fail to report to the supervision officer as directed for the months of July and August 2023, in violation of condition number 4.
How do you plead to that? True or not true?
True, Your Honor. Your Honor will waive the remaining violated conditions.
No objection, Your Honor. Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes.
Court is going to find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor.
Yes.
And that is to deny the motion and to amend for bi-weekly drug testing and bi-monthly office visits for 4 months. And it says 0 tolerance.
Okay. All right, Mr. Rodriguez, you want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand, state your name for the record.
Abel Rodriguez.
All right, Mr. Rodriguez, why are you doing poorly on probation?
It was a family issue. My father was passing away, and my support group was mainly in Arizona. And he sadly passed away, and I came. Now I turn myself home.
But how does not reporting and not showing up to probation help you?
It didn't help me at all. He even got very upset, very disappointed. So,
And do you want to go to prison?
no,
Do you want to go to the Bexar County Jail and live there?
no, yeah.
All right, because if you want to be at the state jail for 2 years, we can help accomplish that for you.
No, Your Honor, that's
Can't give you a toothbrush. I know there was a previous judge, they said we give toothbrushes and hand those out. I'm not going to give you a toothbrush. Toothbrushes are expensive now anyway. So it won't, if I were to give you one, it wouldn't be an Oral-B one. It would be one from the Dollar Tree that's now $1.25. All right?
Yes, sir.
So the family you have in Arizona, who's in Arizona?
Right now, since my father is deceased, just a couple cousins, and that's all.
So where's your support group?
My support group is just mainly my reservation and my mom's side of the family that was on there. And I have my children out there as well.
Okay, so do you want to remain in Bexar County or is there some other place?
I'm gonna have to remain here and take care of this. I let them all know that and they're willing to move out here, make the change.
All right, why not back on the back at the reservation
There's
location?
too much emotional toll that I have out there, and I'd rather remain out here. My father wanted me to stay out here.
Okay. All right. I'm going to deny the motion. Alternate amend conditions to include a MIC evaluation and probation. What are your thoughts?
Your Honor, Sam and I discussed a probation price on the court summary, and I feel like that may be appropriate.
All right.
I'd like to get a tap evaluation.
All right, so we're going to do a MIC evaluation, a TAP evaluation, and probation. If he does the TAP evaluation in jail, how long will that take?
About a week and a half to search.
All right, so we're going to do the TAP evaluation in custody. All right, because if we were to do it out of custody, it's how long out of custody? All right. So MIC evaluation and TAP evaluation while in custody. Follow recommendations from TAP. And we can also do a referral to felony drug court. Because I know they have a dual diagnosis program. Is there anything else you need from the court to be successful?
No, Your Honor.
All right, so you need to make sure you report. That's what you have to do. Problems happen in your life, you still have obligations.
Yes, sir.
And this is an obligation that could result in you going to the state jail facility. You understand?
Yes, Your Honor.
All right, we can go off the record. What's with the tattoo on the side of your face?
It's a Catholic cross. I was supposed to be a lot smaller, but guy did it way bigger than I expected.
Well, was he doing it freehand?
Yes. Yes.
Oh,
And
see,
then
if he were not, don't let people do tattoos freehand unless you know their work. Because if he wasn't doing it freehand, he would have had it stenciled and you could say that's too large.
Yes.
You can still have that removed if you want. It's just going to be extra painful.
So I was looking into that.
All right, if you need anything from the court or you feel like probation is not addressing issues, you can always come back to the court. You understand?
Yes, sir.
All right, good luck to you, okay? All right, this is family violence.
Judge, this was a plea taken by Judge Angelini on an agreed deferred before the court now.
All right.
I'll take the 7 for the
All right, court is calling 2023 CR 7903, State of Texas versus Frank Daniel Torres. Can I have parties announced for the record for the state?
Ally Jackson for the state.
Michael DeLeon for Mr. Torres.
All right, you entered a plea of no contest
That's correct, Your Honor.
in front of Judge Angelini. We're here for sentencing. Have you, counsel, received the PSI report?
I have reviewed it, Your Honor, and we're ready to proceed.
All right. State, have you had a chance to review the PSI report? Any objections?
No objections, Your Honor.
All right. According to the plea bargain agreement, state is recommending deferred adjudication. Is
Correct.
there anything you wish to say on behalf of your client?
I would just notice that the PSI doesn't recommend any type of mental health treatment, any type of drug or alcohol treatment, Your Honor. I know he's had deferreds in the past. He does have a good reason to, on this felony, defer to succeed in that he has an 11-month-old daughter now. He's also not working right now, Your Honor, so we're going to ask the court if we can probate any type of fine or perhaps cut down on the probation fees to the bare minimum. He is actively seeking work and he has a job interview this afternoon.
All right. And with regards to the complainant, I don't see in here where there's no contact with Sonia Esparza. Do you know no contact means that you are not to have any contact with her? That means no letters. Do y'all have children together?
We do. We have an 11-month-old.
All right, there's to be no Mother's Day card or anything of that nature.
Yes, ma'am.
And if you want to have contact with your child, you will need to do that through a third party. Do you understand?
That's what we've been doing. Yes, ma'am.
All right, the court is going to sentence you to a $1,500 fine. And to the clerk, this is the second degree. Could you let me know what the court costs are? That will be probated. There's to be 5 years deferred adjudication. No contact with Sonia, Sonia Esparza. The BIPP course. There's an affirmative finding of family violence. 100 hours of community service restitution. I'm going to order parenting classes. That can be with Rainbows. Once you complete parenting classes, the court will deem your community service hours satisfied. There's to be regular reporting by Zoom or in person. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors.
Judge, that's 375.
Thank you. There's to be regular random UAs. And you can have a patch if you so choose. The patch just costs more. Your court costs are approximately $350, maybe $380. Will you be able to pay that in installments?
Yes, ma'am. If given the opportunity, yes, ma'am.
Okay. There's going to be field visits 1 time per month for 3 months. And then thereafter at probation's discretion. Probation, is there anything else you need? Is there anything else you need from the court to be successful?
No, ma'am, thank you.
All right, I'm going to show you what is entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am, I did.
Because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am, I do.
All right, we can go off the record. I'm serious about that no contact. Do you understand?
That's not a problem, ma'am.
So if you have contact with her, a violation report is going to be submitted to me. If it's in proper order, it's going to be signed and you will be looking at how much time in prison?
I believe it was 20. Did you say
20 years.
20? Yes,
All
ma'am.
right. Do not contact her. Do not get together with her for family vacations. None of that. Do you understand?
That's not a problem.
And it appears that you may not be ready for a relationship. Get an orchid. When you get an orchid, they come with blooms on them. Once those blooms fall off and you get it to rebloom, you may be ready for a relationship. Do you understand?
Yes, ma'am.
And do you have an orchid?
Oh, I will never own an orchid, ma'am.
You need
Thank
to get one because you're not good in relationships.
I beg to
This is
differ,
the
yes, ma'am.
this is the second offense for choking.
Okay,
That is why it's a second degree felony.
yes, ma'am.
Otherwise, it would be a third degree felony. And if this was the first assault case you had, that was just a regular assault, you would be in misdemeanor court. So obviously, you are not a good person to be in a relationship. Good luck.
Thank you.
Thank you, Judge.
You're welcome. Court is calling 2023 CR 3275, State of Texas versus Robert Perez. Can our parties announce for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Victor Gomez for Mr. Pettis.
And are you Mr. Perez?
Yes, ma'am.
Going to show you what's entitled Motion to Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Robert Perez who was placed on community supervision in 2023 CR 3275 for the offense of tampering with evidence on July 17, 2023 for a term of 5 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 41, on or about the 19th day of December 2023 in Bexar County, Texas. The defendant, Roger Perez, did then and there fail to comply with the rules and regulations of the felony drug court by failing to call the urinalysis line in violation of condition number 41.
How do you plead to that? True or not true?
True, ma'am.
And Your Honor, we waive the other violations alleged in the motion.
Any objections?
No objection.
Did you understand by pleading true to violation? Excuse me, if you all could not talk so close to the court reporter. Did you understand by pleading true to violation of condition number 41, the court could find it true, grant the motion, and sentence you up to 5 years in prison and up to a $2,000 fine? Knowing that, do you still wish to plead true to violation of condition 41?
Yes, ma'am.
A court will find violation of condition number 41 true. Is there a proposed agreement?
There is, Your Honor. We're asking that you deny the motion and continue the defendant on probation. And we're asking that he attends the state ISF cognitive track, followed by ISP supervision, which is the probation recommendation.
All right, and probation, that's what you're asking for? All right, Mr. Pettis, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. State your name for the record.
Robert Pettis.
All right, why are you not following the court's instructions and following the rules on probation?
Well, I was just really depressed about my daughters. I mean, this is the longest time I ever been without them. And
Whose fault is that?
yes, ma'am, I understand.
So you can't come to court and saying, I'm depressed about my daughters, and this is the longest time I've been without them. And the reason why you're without them is because of your own actions.
Yes, ma'am, I understand.
So that's no excuse. So why are you not doing what you need to do on probation? Do you want to go to prison?
No, ma'am. No, ma'am.
So why are you not doing what's being asked of you? I don't understand.
I was just really depressed and I didn't, I forgot to call.
How can you forget to call and you're looking at 5 years prison?
I tried my best now and then I was just, it was overwhelming. I don't know, I mean, I apologize. I know all my excuses ain't good enough. I know
No.
I could do, I'm just trying to do better in my life and, I think this, I just said, but, well, I'm gonna.
And you know felony, and you know the reason why felony drug court wouldn't accept you, right? And it's based upon some of the allegations in the motion that that the state is not proceeding on. You understand that?
It's not.
So, you all are saying ISF? All right, the court will deny the motion. Alternate main conditions to include ISF and the UA hotline until further notice. Is there anything else?
Nothing further from defense.
All right, is there anything else you need from the court to be successful?
No,
I mean, your attorney is not on probation, you are. Is there anything else that you need?
I'm just planning to do better with my life and I'll follow all the directions. And I messed up. I do agree and it's my fault. And I do accept the responsibilities and I'm just willing to do better.
All right, good luck to you.
All right, thank you, ma'am.
You're welcome. All right, so I ordered inpatient treatment.
You did, Your Honor, and I very much want to speak to the court on that.
Mhm.
In the last 2 months, Ms. Holland has taken and passed over 20 drug tests through her probation. She's taken a drug test today and passed that. She's currently attending.
You knew I was going to ask for a drug test, didn't you?
I did, Judge. And so we did that and she passed that. She's attending NA meetings twice a week right now. And she has been completely drug-free for the last 7 months since she had the one dirty UA that caused the court to believe that she needed inpatient treatment. She's been calling every single day to the drug hotline since June of last year. She lives alone. She owns her own house. She's been employed at Cowboy Grading, where she's currently employed for the last 14 years. She's working 40 hours a week. She has a dog that she's had for the last 7 years.
Oh, what type of dog is that?
That's a black lab.
Okay.
And
You have an answer to all my questions. I wanted to know.
well, I know this court asked very good questions, and so I wanted to make sure that I asked her that because I thought that you might ask that actually.
But it's not a closed book exam.
Well,
That's an inside joke between us, but okay.
and I won't make any comments to that, but I do have my opinion on that. And she's in complete compliance otherwise with her conditions of probation. When the court ordered the inpatient or added the inpatient as a condition, on her own initiative, she went and enrolled herself in outpatient at Lifetime Recovery. And she had already started the Lifetime Recovery actually before the court ordered the inpatient. And actually 1 month after the court amended it on November the 9th of last year, she completed her Lifetime Recovery IOP program. And so we recognize the court's concerns. She remembers the talking to that this court had with other defendants that were in similar situations during her time getting up to, and I wasn't her trial counsel at the time, by the way, but in her time in this court, she recognizes the serious nature of being on probation, and she did relapse last June, but she's been drug and alcohol free since that time, and I think has demonstrated her ability to remain drug and alcohol free. And so we're asking the court to not require her to do the inpatient.
All right, can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Amber Hollins.
All right, so what treatment are you in?
At this time, I'm
Yes.
going to NA twice a week.
Okay. And so you completed the lifetime recovery
Correct.
and you're still doing the UA hotline?
Yes, ma'am. Every day I've called for almost, it's been over a year.
Okay. So this is what the court will do then, unless there are any other questions?
No questions, Your Honor.
All right. So you're going to continue doing your NA for 2 times per week. Ms. Abrams, we're going to continue with the UA hotline, but with the UA hotline, it's only going to be testing. We're going to start out with testing once every 2 weeks, and then we'll do testing once every 3 weeks, then testing once a month. I still want the UA hotline there because it's random.
Not a problem.
So one day you may have to test, one day you may not have to test. So we're going to handle this in incremental stages until you're on for regular testing. All right?
Ma'am.
Do you have any questions about anything?
No, ma'am.
Anything else from either side?
No, ma'am, Your Honor.
All right, keep up the good work, okay?
Thank you.
That excuse?
Did you review that with your attorney? Did you understand it? And just like that, the system is forced to answer. A missing video, a broken audio feed, and an IT department that tried to hide behind an HR policy but now has to face the judge in person. Justice might take time, but when a judge refuses to be played, the truth always finds a way out. Make sure to share this video and let me know if you think the defendant will finally get a fair shake.